Dear learners, welcome to this session. Today we will be discussing Right to Information Act 2005, which got amended in 2019. And the objectives of this session are, you will be knowing the procedure of obtaining information. This will also explain you the procedure and timeline for disposal of request. We will discuss the exceptions to RTI. We will also discuss the grounds for rejection to access in certain cases, and we will explain the severability clause and third party information. So, first is request for obtaining information. If any citizen of India wants to ask any information under the RTI Act, then what will be the procedure? A person who desires to obtain any information under this Act shall make a request in writing or through electronic means. RTI can be also filed online in English or Hindi or in the official language of the area in which the application is being made. A very important provision, that it can be in English, it can be in Hindi or the official language of that area. If you are illiterate, then there is no issue. You will be just picking up your questions, and there will be a person who will type it for you, who will write it for you, and then he will just read it to you, and then you can just put your thumb impression, or if you can just sign, you can sign. So, this is very easy. It is not important that you need to be an advocate for this. It is not important that you have to be literate for this. Every commoner of this country, can ask for information under the RTI Act. You have to accompany your application with such fee as may be prescribed to the Central Public Information Officer or the State Public Information Officer, as the case may be, of the concerned public authority. A very important point. Many a times, we do not understand that, okay, we need to get this information, but where should we send this application for that information? So, that has to be in the concerned department only. And there is also a provision that if you are unaware about that and your application goes to the wrong place, then the PIO is duty bound to send it under intimation to you at the right place for getting that information. Specifying the particulars of the information sought by him or by her is very important, I cannot ask you anything and everything under the sky, under the sun, or I have to be very specific when I am asking for any information. This you will understand when we discuss the exceptions of RTI. Provided that where such requests cannot be made in writing, the Central Public Information Officer or State Public Information, as the case may be, shall render all reasonable assistance to the person making the request orally to reduce the same in writing, which we have just discussed right now. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. So, you are asking for information, so rest assured that nobody will harass you or nobody will ask you complicated questions as to why are you asking this information, who are you to ask this information, but it should be a bona fide application. Where the application is made to a public authority requesting for an information which is held by another public authority or the subject matter of which is more closely connected with the functions of another public authority, which I just explained, The public authority to which such application is made shall transfer the application or such part of it as may be appropriate to that other public authority and inform the applicant immediately about such transfer, provided that the transfer of an application pursuant to this subsection shall be made as soon as practicable, but in no case later than 5 days from the date of receipt of application. So, if you do not have that information, you cannot just sit with that application and later on after 20 days, 30 days or 50 days, you find one fine day you just write the reply that this does not pertains to our department. You have to forward that application to the concerned department and you have to also intimate that person who has sent that application. Disposal of request. Subject to the proviso to subsection 2 of section 5 or the proviso to subsection 3 of section 6, the Central Public Information Officer or State Public Information Officer, as the case may be, on receipt of a request under section 6 shall, as expeditiously as possible and in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in section 8 and 9. So, this is very important. You just cannot take that application and keep it with you with no response. Provided that where the information sought for concerns the life or liberty of a person, the same shall be provided within 48 hours of the receipt of the request. So, when the life is in danger or liberty is in danger, then within 48 hours of the receipt of the request, you have to provide that information. If the Central Public Information Officer or State Public Information Officer, as the case may be, fails to give decision on the request for information within the period specified under subsection 1, the Central Public Information Officer or State Public Information Officer, as the case may be, shall be deemed to have refused the request. Where a decision is taken to provide the information on payment of any other further fee representing the cost of providing the information, the Central Public Information Officer or State Public Information Officer, as the case may be, shall send an intimation to the person making the request. So, it is very important. You cannot just keep that application and say that it does not pertains to me after a period of 30 days or after a period of 90 days of that application. You just cannot say after 30 days or 50 days, one fine day you are approached that why did you not answer, and you have the reason that the fees was not appropriate. So, if there are additional fees to be paid by the applicant, you have to inform that person who has made the request. And you have to give the details of further fees representing the cost of providing the information as determined by him, together with the calculations made to arrive at the amount in accordance with fee prescribed under subsection 1. Requesting him to deposit that fee and the period intervening between the dispatch of the said intimation and payment of fees shall be excluded for the purpose of calculating the period of 30 days referred to in that subsection. When there is a question of bona fide intention on the part of the PIO, it is very important that we have seen that in some cases on the 30th day, the PIO will write that you have to provide me this much of fees and give the details. So, it is not that you have to just sit with that application for 30 days and on the last date you ask for more fees from the person or more details from the person. So, you have to act in a reasonable manner. Information concerning his or her right with respect to review the decision as to amount of fees charged or the form of access provided, including the particulars of the applicant authority, time limit, process and any other forms have to be provided. We have seen that in few cases there is a big debate on the person, because whether that person has acted in a bona fide manner, in a reasonable manner or not, or whether that person has just kept that application with him and after 30 days he is just writing or she is just writing that I need further fees to provide you this information. And if a person is below poverty line, then every information provided to him or her will be free of cost. Where access to the record or a part thereof is required to be provided under this Act, and the person to whom access is to be provided is sensorily disabled, the Central Public Information Officer or State Public Information Officer, as the case may be, shall provide assistance to enable access to the information, including providing such assistance as may be appropriate for the inspection. Where access to information is to be provided in the printed or in any electronic format, the applicant shall, subject to the provisions of subsection 6, pay such fees as may be prescribed, provided that the fee prescribed under subsection 1 of section 6 and subsection 1 and 5 of section 7 shall be reasonable, and no such fee shall be charged from the person who are below poverty line as may be determined by the appropriate government. So, as we just understood that you cannot ask for fees from people who are below poverty line, and the fees you are demanding should be reasonable. Notwithstanding anything contained in subsection 5, the person making request for the information shall be provided the information free of charge where a public authority fails to comply with the time limit specified in subsection 1. Before taking any decision under subsection 1, the Central Public Information Officer or State Public Information Officer, as the case may be, shall take into consideration the representation made by a third party under section 11. Where a request has been rejected under subsection 1, the Central Public Information Officer or the State Public Information Officer, as the case may be, shall communicate to the person making the request the reasons for such rejection, the period within which an appeal against such rejection may be preferred, and the particulars of the appellate authority. So, you have to mention with rejection, you have to tell him that what are the reasons for such rejection, what is the period under which you can file an appeal against that rejection, and the particulars of the appellate authority. And information shall ordinarily be provided in the form in which it is sought, unless it would disappropriately divert the resources of the public authority or would be detrimental to the safety or preservation of the record in question. Exemptions from disclosure of information, a very important section. Notwithstanding anything contained in this Act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interest of the state, relationship with foreign state or lead to incitement of an offence. So, these are the exceptions. You cannot ask for information which will affect the sovereignty and integrity of the country, the security of the country, the strategic, scientific or economic interest of the state, or relationship with a foreign nation, or which will lead to incitement of an offence, one may feel offended and you may do an offence. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. So, you need to be aware about the law of the land. As a librarian, you need to know what information you can give and what information you should not give. So, this is very important that you have to act in a reasonable manner. As a bona fide citizen, you have to act as a PIO sitting in that position. You are duty bound that you should clearly understand the exemptions, and you should have this mindset that this right is not absolute, it has certain restrictions. Information the disclosure of which would cause a breach of privilege of Parliament or the state legislature, information including commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive positions of a third party unless the competent authority is satisfied that larger public interest warrants the disclosure of such information. A very important point. Information available to a person in his fiduciary relationship unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information received in confidence from foreign government, information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. So, there are law people, so you cannot just ask any information, and the government of India will not share all the secret informations with you, because the sovereignty of the nation is very important. You cannot ask a person about his medical health. You cannot ask a doctor, that this is, he is your patient. So, you just tell me whether he is suffering from this disease or not, because a doctor has a duty not to disclose the medical health of his patient. So, this will be decided on case to case basis. As a citizen, I have to understand that I cannot ask anything and everything under the sun. Information which would impede the process of investigation or apprehension or prosecution of offenders will also not be disclosed. Cabinet papers including records of deliberations of the Council of Ministers, Secretaries and other officials are also exempted. One important case wherein a group of media personnel wanted some information regarding a very popular case. So, in that they tried a lot to get information from the police station, but the police station did not provide them the information because it was a violation of the accused human rights. So, you have to understand that a person may be an accused but is not a convict. So, you cannot have media trial, you cannot force a government machinery to provide you with the evidences so that you can show it on your TV screens. One has to be very sensitive and one has to understand what information can be parted under the Right to Information Act and what information cannot be parted under the Right to Information Act. You have to look at the person's right to privacy also, and you have to ensure that the conflicting interests are not there when you provide information to the person. provided that the decisions of Council of Ministers, the reasons thereof, and the material on basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Provided further that those matters which come under the exceptions specified in this section shall not be disclosed. I want information about the military operations. I want to know how many people are deployed at a particular checkpost. I want to know what are the financial strategies of Government of India. So, can I ask these informations? There is a big no. This is covered under the exceptions. I cannot ask for confidential information because it can affect the security of the nation. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual unless the Central Public Information Officer or the State Public Information Officer or the appellate authority, as the case may be, is satisfied that the larger public interest justifies the disclosure of such information, provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. A very important point, there are certain rights of individuals as human rights. It can be related to their dignity, it can be related to their privacy rights, but one has to understand that whether after giving that information it will help the common people or it will create more problems for the person of whom you are sharing the information. In cases of COVID, when you share the information, that information is not violating the person's right, but you need to curtail the spread of this virus. So, you have to act in the interest of the general public at large. So, you have to differentiate and you have to make a reasonable classification on the basis of every case. You cannot say that in X case you have not provided me the medical details of this person, but in Y case you have made it public. Everybody is knowing that yes, this person is having this medical condition. So, it is something which can be settled case to case basis. Notwithstanding anything in the Official Secrets Act 1923, nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. Subject to the provisions of clauses A, C and I of subsection 1, any information relating to any occurrence, event or matter which has taken place, occurred or happened 20 years before the date on which such request is made under section 6 shall be provided to any person making a request under that section, provided that where any request arises as to the date from which the said period of 20 years has to be computed, the decision of the central government shall be final subject to the usual appeals provided in this act. Grounds for rejection to access in certain cases is enumerated under section 9 of RTI Act. Without prejudice to the provisions of section 8, a central public information officer or a state public information officer, as the case may be, may reject a request for information where such a request for providing access would involve an infringement of copyright subsisting in a person other than the state. Then there is a severability clause in section 10 where a request for access to information is rejected on the ground that it is in the relation to information which is exempt from disclosure, then notwithstanding anything contained in this act, access may be provided to that part of the record which does not contain any information which is exempt from disclosure under this act and which can reasonably be severed from any part that contains exempt information. A very important provisions, you have asked for three things. One thing is something which I cannot give you as a public PIO, because that is under the exceptions. But the second point I can share with you, I can give information about this because this is not under the exceptions. So, I can just sever or I can just cut that portion and provide you the information about that portion instead of rejecting your application completely on the basis of exceptions. So, you can sever the part which is not under the exceptions and provide information on that part. So, here is the role of the PIO, because he has to understand that which information is confidential, which information is against the law, which information is under the exceptions of RTI, and which information can be provided to that person. Where access is granted to a part of the record under subsection 1, the Central Public Information Officer or State Public Information Officer, as the case may be, shall give a notice to the applicant informing that only part of the record requested after severance of the record containing information which is exempt from disclosure is being provided. The reasons for the decisions, including any finding on any material question of the fact, referring to the material on which those findings were based, the name and designation of the person giving the decisions, the details of the fee calculated by him or her, and the amount of fee which the applicant is required to deposit, and his or her rights with respect to review of the decision regarding non-disclosure of part of the information, the amount of fee charged or the form of access provided, including the particulars of the senior officer specified under subsection 1 of the section 19, or the Central Information Commissioner or the State Information Commissioner, as the case may be, time limit, process, and any other form of access. Third party information is very important. Where a Central Public Information Officer or a State Public Information Officer, as the case may be, intends to disclose any information or record a part thereof on a request made under this act which relates to or has been supplied by a third party and has been treated as confidential by that third party, the Central Public Information Officer or State Public Information Officer, as the case may be, shall within 5 days from the receipt of the request give a written notice to that third party of the request and of the fact that the Central Public Information Officer or State Public Information Officer, as the case may be, intends to disclose the information or record or part thereof and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed, and such submission of the third party shall be kept in view while taking a decisions about disclosure of information. So, if the information has been provided by the third party, then you cannot give the information without his consent, provided that except in the case of trade or commercial secret protected by law, disclosure may be allowed if the public interest in disclosure overweights in importance and impossible harm or injury to the interest of such third party. So, if public interest is involved, then you can give this information. So, the interest or the harm or injury of the third party is more, or the interest, injury or harm to the public interest is more. That has to be calculated, You have to understand that by giving this information, I am doing public good, or by giving this information, there is less harm to the person or the third party who has provided me this information. Where a notice is served by the Central Public Information Officer or State Public Information Officer, as the case may be, under subsection 1 to a third party in respect of any information or record or part thereof, the third party shall within 10 days from the date of receipt of such notice be given the opportunity to make representation against the proposed disclosure. Notwithstanding anything contained in section 7, the Central Public Information Officer or State Public Information Officer, as the case may be, shall within 40 days after the receipt of the request under section 6, if the third party has been given an opportunity to make representation under subsection 2, make a decision as to whether or not to disclose the information or record or part thereof, and give in writing the notice of his decisions to the third party. A notice given under subsection 3 shall include a statement that the third party to whom the notice is given is entitled to prefer an appeal under section 19 against the decision. So, now it is very important that you have to understand that as a librarian, you have to differentiate between the public good and the rights of the third party. You have to ask questions to the third party, you have to give them reasonable time, and if you do not receive any response, then also you have to intimate them and tell them that this is the case, this is the information which we are providing, and you can appeal against this decision. So, now you have understood the procedure of obtaining information, what is the procedure, what are the timelines, and what is the procedure for disposal of request, what are the exceptions to RTI, what are the grounds for rejection to RTI in certain cases, and the severability and the third party information clause. So, hope you had a good learning experience and you are safe and sound. Thank you all for this session. Have a nice day.